Child Support Collection Unit, or CSU, filed a motion to vacate. They said that two things. One, that my client did not exhaust his administrative remedies, meaning that the law sometimes says that before you can ask the court to review something, you first have to, jump through the hoops, follow steps A, B, and C. And in this case, he was supposed to challenge their suspension order. And if CSU then denied the challenge, he could have then objected in family court. But as I said, they didn't accept his challenge. In fact, we filed a second challenge when we found a provision of law that said if you did not receive actual notice of the challenge like he did and you prove it, which he did, then you can challenge it at any time. And they still wouldn't accept it. So we actually tried to challenge it twice. So the court agreed with that on us. And then the other thing was that CSU said, well, that's great. Even if he exhausted administrative remedies, the family court does not have jurisdiction to tell CSU what to do. That state law and federal law and administrative law all vest this authority, enforcement authority in CSU, which is true. They're the ones who, if you pay child support or someone pays child support to you and it's not paid to you directly and it goes to the state, they collect the money and then they pay you. So they have a lot of different enforcement mechanisms at their hands, at their fingertips, including suspending a driver's license and another professional license, such as an attorney license or a medical license. They can take your tax refunds. They can do income executions. They can seize assets, bank accounts, lots of different things they can do. In this case, they decided to suspend the driver's license. But I had said, even initially when I filed the order to show cause, that there is a statute in the Family Court Act, I think it's Section 454, but don't quote me on that, that says that although the family courts are courts of limited jurisdiction, meaning they can only do what the legislature has told them they can do, they are allowed to vacate orders. They're allowed to modify. They're allowed to do a lot of different things if it's in the interests of justice. And in this case, it seems pretty obvious it was. Why? Because this is a person who's in this catch-22. He gets his driver's license suspended, loses the job that he can work legally in the U.S. on. He then, if he goes back to his country, he won't earn that money. That's in the child support order. They won't lift his suspension because he owes the money. But he can't pay the money until the suspension is lifted and he can get the new job. So it's just kind of going back and forth. And that's a good place for the court to step in, especially we explained in the motion about his immigration status and the fact that he really did. It was really, despite that we're still fighting this fact that he didn't intentionally miss court. He had a reasonable excuse or excusable neglect, however you want to put it. Even though some of the other support magistrates didn't find his story to be credible for whatever reason, we are currently appealing that. But again, the arrears are still piling up. Every month he owes child support based on an amount that he doesn't come close to earning. So I was happy to say that the judge granted the motion, or not granted, we didn't file the motion, denied the motion in the entirety, saying that they do have the power to correct wrongs against innocent people when it's in the interest of justice, just as I said. It is not a final decision. There's basically CSU has 30 days to object.